information. If you are looking for verification of title to see whether or not there's an encumbrance, you have to go to the office of the registrar of titles, and that's like the land registry to figure that out. What you may tend to find is that some states they migrated to electronic search, and some are still in the analog age where you do physical search. What we have seen is, like they say about a computer, it's what you input that you find there. You find officers who are lagging behind to upload filings in the hard copies onto their system, and you just take on the face value the report or the contents of what you have seen online. For that, for somebody who is extremely diligent, particularly in a country like ours, what we do is you ask for the physical file, look at the electronic copies that they have, and then come up with a result. That would help you a lot, because we've seen situations where some people had filed some caveats on properties, or there has been some encumbrance, but they just didn't upload them and you don't find them electronically. So it's a combination of both. So if you want to do title searches, I did mention land registry, I did mention Surveyor General's office, and if CAC is involved or company's house, you may need to go, because there are times that there are charges over such asset class. So that would be an corporate affairs commission to know whether or not the company had used it as security for a loan or other obligations that they may have.
Okay. And then now we talked about mistakes that real estate investors could make. Are there laws, to protect real estate investors who might have made these mistakes already? And for instance, like the case that you mentioned, the scenario you mentioned, are there laws to protect them from these mistakes? Or
Okay, I think for me, why would you want to fall into those mistakes in the first place? The first thing is, I got you. The first thing is try and avoid them. If you
yeah,
can avoid them, please avoid them. But if you run into that, I think there are options. Government have put in place some requirement for registration of some transactions, which is why we did run through perfection of title earlier on. So if they are registrable documents, you would expect to find them, at the registry when you go check for those. And if somebody has not put them out there, which is meant to be notice to the general public as to the status of those properties, then they may have themselves to blame. Because if you have done your search and you have that as a search report, it could be a way to try and impeach whatever adverse claim there is on that property before you took your own action. I think the other part is the title documents we talked about. They are referred to as prima facie evidence of title. Excuse the legal balance. It means that they are just like evidence of title, but they are not foolproof in themselves. So they can be impeached and all of that. And how do you do that is to go to court for justice and all of that. So one is protection by way of making those information available through the registry, because most of those transactions are registrable. The second is if for any reason you haven't done all you need to do, you still had to maybe fall into wrong hands, you have the courts to utilize for necessary remedies.
okay. Thank you, sir. So that's one in terms of fake documentation, or now in terms of in case of fraud, or paying to the wrong hands and all of that. Sometimes it could actually be paying to the right company, but again, the property in question is not available, and then there's a lot of back and forth. Sometimes people don't know what steps to take, they don't know what to do, and then just like sometimes they end up leaving, that money that has been paid. What legal actions can such investors take, especially in cases whereby the company was a legit company? It's not like it was a scam or a setup. No, it's a legit company. But like I said, the property in question here, you can't access the property. So for instance, a land, you can access the land and you paid the company for the land. What steps can you take, to get back your capital or your investment?
Okay, so I think in my view, there are three options available to such an investor. One is to try and resolve amicably as a first step, because in these situations where particular properties or developments come from a family or a group of people or a community. What you tend to find if for any reason you can't find the land you paid for is that they could offer you a replacement land for that or offer you cash if the land you had paid for isn't available anymore. The second option that you have, if you are still not satisfied with that, is to pursue a civil action for breach of covenants, breach of contract. And what that does for you is that it gives you damages, and there could be other ancillary liens that you can get. It gives you your money back in terms of if you are successful in that claim, a civil action. The other part of the civil action may be specific performance. It's an equitable remedy. It's basically you asking the court to tell vendor, that's the seller in this case, to do that which he ought to do. But that's on the assumption that he truly owns that property. If he doesn't have legal title to it, you can't be asking for that because he cannot give you what he doesn't have. But if you are convinced that he has title to it, you could actually ask the court to mandate him to transfer that property to you if that property is still available. There's a third leg of it, and that's a criminal action that is available for you. But I must say that that doesn't in itself bring back the money. It's just a term of imprisonment for fraudulent activities. Again, you may need to do much more in terms of you proving that the person actually defrauded you. I think what they say for those who do criminal cases that it has to be beyond all reasonable doubts, all your allegations. So you could submit a complaint or a petition to the relevant law enforcement agent for investigation, and if they find it necessary, prosecution of the culprits. So, like I said, that does not bring back the money, but you could be lucky in a situation where somebody is afraid of going to jail and quickly pays back your money. But it's not advisable if what you want money, because you may as well just try and defend it all the way. And then I think another important point is that both options of you going to a civil action as well as a criminal action can be pursued simultaneously. So you're not really losing anything if you do a double pronged approach to try and seek remedy in the court of law. So those are the options available to any investor who has found himself in such a situation.
Okay, thank you, sir. Also, so I know that you mentioned that you get a legal representative, before you begin the transaction process so that you don't make mistakes and all of that. Now, how can you identify or how can a prospective investor identify a, a legit legal representative in this case who can actually take up his transaction? What's the difference, or what are the features to look out for while selecting a legal representative?
Okay. I think from where we sit, that the legal framework is a given, that you know how to do due diligence is also a given, that you can draft, should also be a given. All of those three are in the basket for us. So how do you know who to trust your investment portfolio with? It's about how commercially aware is the lawyer or is this legal partner. If you're engaging a lawyer or you're speaking to a legal partner and he's not asking you some questions other than things around what title do they have, we are going to do due diligence, we will draft for you and all of that, then we should like double check it. So a very competent and commercially aware lawyer would ask you, what do you want the property for? What exactly is the purpose of acquiring this property? When you tell him that, he's looking at the numbers for you, not just the documentation, because it's an investment. When you tell him that, he says, okay, and then he's able to advise you on the location. which is the best location for what you want to do. If it's leisure, it will tell you, no, 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 you're not going to get patronage if you put it in that place. It will tell you, oh, you can't put it there because that place is not for that and all of that. So it's asking you commercial questions, on that investment. So you can tell that, look, this lawyer, beyond technicalities, also understands your objective. And I'll tell you for free, sometimes a difference in your return on investment can be like 50% just within 50 meters. So let's say this is a table, for instance. On the divide, it's just like maybe a few meters in between. You would be shocked to find that property on this side of the divide is worth like 100,000 USD, for instance. And just like less than 50 meters from the same property is going for something of about half. So what exactly do you want? What exactly
Hmm.
I see that you're able to relate to that and all of that. So commercially aware lawyer will tell you, do not go beyond this point because once you go beyond that point, you will not get this rate on that property. And since you want to use it for commercial purposes, I will tell you to end your search here. So that's how you know. He's looking at the end from the beginning. He's asking you personal questions. And don't if you have a lawyer there like a doctors, you have to trust them with all those information and open up. That's how you know a competent real estate and legal practitioner.
Okay. I know that we don't have a lot of time. Um, and then please, for the audience, if you have questions, please kindly um, drop them on live chats, or you can send them. Can drop up a DM on our Instagram page as well. I think Made Nigeria. Will take the questions from there. Um, Now, well, almost like lastly, sir, what advice do you have for investors, current investors first, and then prospective investors, and now real estate agents? So they're the middlemen in real estate transactions. What advice do you have for them?
I think I'll put prospective and current investors in one bucket, and then I'll put their estate agents in another bucket. So the first bucket, I'll advise them seek at the onset, take the advice of a legal practitioner. Do not go into any property investment without being handheld by a legal practitioner because transactions are dynamic in nature. They are very dynamic in nature. And I don't think that because I've done that before, I will do it the same way I did that. The facts are totally different. The facts are totally different and they are peculiar in their own rights. So you have to look at them differently and ensure that you have a legal practitioner to handhold you through that transaction. There could be instances legal practitioner that he will tell you that "Look, I think you also need the services of an estate surveyor and valuer for this kind of transaction. So, and the commission will advise you of steps to take, but never walk into any transaction without having the service of a legal practitioner. And for their agents, I think my advice for them would be that please, and please do not do the work of a lawyer. What we have seen in the industry is the use of precedents, because we've done it before, ranging from just tenancies when you see a tenancy agreement, depending on who that lawyer that drafted is acting for, there'll be some differences in the provisions in that. If he's acting for the landlord, he knows what he's looking for. He knows what he must get into that agreement. So you just look at there's some slight differences between one or two, whatever. It depends on who you're acting for. If you're acting for the tenant, he knows what he's looking for. And all those words, law, they mean something. To you, a layman, they just can give them different interpretation. But in a court of law, we have legal meanings. So don't just take a precedent and then use it, be it a lease, short or mid-term or long lease, or outright purchase. Please stay away from that. It usually does not end well for your clients. So that's my advice to the estate agents. You can still make your money without getting into legal advisory services.
Okay, sir. So I know that you were talking. I knew that that last part was more about rentals. Now, I will still come back to the advice, especially when you are selling prop now sales properties for sales, not rental properties. But before I let's just take one question. We have one question that I would like us to take. Um, so somebody said that there was a time that he wanted to purchase a property and then he didn't find the name. He said one of the documents he saw the name of the owner of the land, and at the final, he didn't state the names of the documents here, but I'm assuming that this was like a JV from what I have seen here. He's saying that he's now at the final document, he didn't see the man's name anymore. So they had transferred. So I'm sure that's like the deed of assignment from the landowner now to the developer. And he's saying that should he go ahead to buy that property because he can't find the name of the landowner at the in the final document in the JV document.
Okay, so I think I understand the structure you are trying to describe. So again, no two transactions are the same. You need a lawyer to advise you on that. And I'll tell you what could have happened because we've had scenarios like that in the past. So it's possible in a JV where initially you had gone to ask for the evidence of title and then they showed it to you and it has ABC as the owner of that property. Because the owner is going to a joint venture arrangement with a developer, you both agree to create a vehicle, in which that property will then be housed and then sold at the relevant time. There will be a transfer of that title from the original person whose name you had seen that title document to the SPV. SPV is special purpose vehicle, the vehicle they are both using to hold it. What you then tend to do is who is going to sign your own transfer documents? Should it be the persons whose name was originally on the title document or the SPV? By the time you get to the registry, ensure that if you are getting it or impress it on them to ensure that that transfer is also perfected so that when you get it from the latter person or latter name, you also have a direct link to the previous person that you saw. So there's a connection of the transfer and you can track it. But if you don't have that, it is better for the holder of that title document at that time to be the one issuing the transfer document. So you don't have to get into a situation of what they call double perfection. Because if it's gone that route before it gets to you, you can only perfect your own after your predecessor in title had perfected his. So that's like a cost, increasing the purchase price of that property. That would be my advice to the person that asked that question.
Okay, thank you. I'm sure the person got that feedback. And there's another one here saying that, okay, so I know you mentioned certificates of occupancy, and so those are like in situations whereby the land has a C of O. These days, lands that are being sold barely have C of O. What is your advice in terms of purchasing a? Is there any other document that I can use as a guarantee when I am when I'm purchasing a land without a C of O?
Okay, so I think CFO is just one of those root of title. We mentioned a couple, it doesn't have to be a CFO, and they all carry equal weight in the eyes of the law. They all carry equal weight. So it could be excision gazetted, that's a good title. It could be C of O, like you mentioned, that's just a statutory right of occupancy. It could be a registered deed of assignment, right? That's a good title. It could be a court judgment as well. It's a good title. It could be a probated will. It's a good title. What you then need to do is once you derive your own title from this title document, you then need to try and register your own title for continuity, for notice to the public, for those who may want to come and claim ownership of your property. It's not just your answer your question, there are other variants.
Oh, okay. Thank you. Thank you for that answer, sir. Again, now this is from us. My question. I know that you talked about perfecting, and from the last statement that you made now, a lot of times when you're telling property buyers to ensure that they have that in mind, that they would have to perfect these titles in their names, it becomes like, oh really, do I need to? They don't really understand that aspect. So I'd like you to sort of like create an understanding around that aspect for prospective investors.
Okay, thank you very much. I think there is a personal obligation, one, on the part of those investors. There's also a legal obligation. So it's a double obligation in that respect. Ideally, before anyone transfers title in a real estate asset, person is expected to have done what we are now calling perfection, which means seek the consent of the governor of that state before you alienate the title in that property. It was meant to be, if all things being equal, it's meant to be in that way. So you get the consent, the governor says you can sell, then you sell to the purchaser. But what obtains in practice is that the purchaser buys it, the vendor transfers obligation to the purchaser to go and perfect. This is a legal requirement. Second one is when you don't do it, there are implications. It's personal, it's your choice. First is if you need to do a secondary sale, you want to sell to a third party, you will struggle if you haven't perfected or it affects the value of your property. They either tell you, oh, go and perfect, or if they see a competing property that has registration, they rather just buy that to save themselves the headache of coming for your own. Let's say you don't even want to sell, you just want to like maybe use it as a security for loan for loans from a bank or banks, as the case may be. Again, they don't see it as clean title, so they probably will not take it from you as security of that loan or for that loan. What you may be able to do with it is just to lodge the documents and with those financial institutions as an equitable mortgage. But most of them really would want a bit of legal mortgage. And if you haven't perfected your own, there's a struggle on the number of perfections that would happen before. So you will probably be limited in terms of use of that property and your ability to use it to secure a loan. You would also be limited in your ability to transfer on the face value of that property. They may offer you something much less than you should have received for it just because you haven't affected your title. So it's actually your call looking at those obligations from a legal and commercial point of view.
Okay, thank you, sir. And so as we wrap up the show, I know that when we asked for advice to real estate agents, it tended towards the rental properties. Now we're talking now for agents or agents in charge of sales properties. What's your advice for them, especially considering the fact that they are the ones that have to explain or show these transfer documents and show, because rentals, there's really no need for all of that if you're renting a property. So what's your advice for real estate agents in charge of transactions for sale properties?
Okay, so the advice is not different. I started off by saying either for sale or even rentals and all of that. So it's not different. Don't try to do the work of a lawyer. I told you you have to see the end from the beginning. It's a lawyer that can advise on the structure. A lawyer will tell you on the necessary documentation based on his findings, during his due diligence, and has to create a nexus between that due diligence report as well as his documentation. So if you are going to get into that, you are going to put your clients in a lot of trouble because the precedents you'll be using, because that's what I see, because you are not trained to do that, will probably be from previous transactions, and those transactions are not the same. They are not the same in all respects. So the advice is whether it's for outright sale, whether it's for long lease, whether it's for short lease, whether it's tenancy, you will not be tempted to get into that realm of involving yourself in documentation. As a matter of fact, it will be something much more than you just putting your client in trouble. It will be personal liability and for that, depending on the nature of the matter. So that's the advice to students. Your job, yeah, I think, is to find, bring the parties together, recommend, if you want to stretch it, and which your clients should go for, and then get your the money for the services rendered, not documentation.
Hmm. Okay. Okay, thank you, sir. So we have to wrap up the show at this time. I think we've taken the most questions that we could take. We'll send you all the questions that we couldn't take here, and then we can also communicate your feedback to the public as well. Thank you very much, sir, for joining us once again. It was very insightful, and thank you to everyone who joined us live. The show is happens every fortnightly, happens fortnightly, and so we'll be back again in another 2 weeks to discuss solutions to questions that you have in terms of investing in real estate and growing your wealth through that. My name is Imelda. Thank you once again for joining us, and enjoy the rest of your day. Thank you, sir.
Thank you very much, Imelda. Nice to be on the show. It's wonderful experience.
All right, sir. Thank you.